I'm Sarah Phillips, and I'm with Phillips Law, a criminal defense firm based out of New Orleans, Louisiana. Today we're talking about preliminary hearings, sometimes called a preliminary exam or just a prelim. If your attorney or the judge mentioned this hearing, you might be wondering, what exactly is this and what happens at this day in court? Now, let's walk through it in simple, real-term language. So what is a preliminary hearing? A preliminary hearing is a checkpoint. It's not a trial. No one is deciding guilt or innocence yet. The judge is only asking one question. Is there probable cause to believe a crime was committed and that this person committed it? If the answer is yes, the case continues. If the answer is no, the charges might be dismissed, at least for now. So, does everyone get a preliminary hearing? Not always. In Louisiana, these hearings usually come up in felony cases, especially when the district attorney hasn't yet formally accepted charges yet. Sometimes your attorney may strategically request one to challenge weak evidence or to get a sneak peek at the state's case, which is a great way to do that. Here's the basic flow. The district attorney will go first in this hearing. They usually call a police officer to testify about what led to your arrest. The officer will give their version of events, of course, under oath. Then your defense attorney gets to cross-examine the police officer. This means we're going to ask questions, challenge inconsistencies, and look for gaps in the state's story. Once both sides finish, the judge then decides, is there probable cause or not? And then that's going to determine what happens next. So, are you going to have to testify? We don't put clients on the stand at preliminary hearings unless there's a very specific reason. Even if you're confident testifying comes with a risk, you could say something that comes back to bite you later, especially if the case goes to trial. Our job is to protect you, and often that means keeping you quiet and letting us do the talking. Cross-examination can be really hostile and aggressive. So why does this prelim even matter? Because even if the judge finds probable cause and the case continues, we've now got a locked-in officer's testimony. We've exposed weaknesses in the state's case. We've gathered as much information as possible for motions, negotiations, or trial. And in some cases, if we win, the charges can be dropped altogether, even though the DA will have the right to refile motions later if they can. It's a very important next step for your attorney to be doing the preliminary examination if if you've been arrested. So if you're a current client and you have a preliminary examination coming up and you're a little confused, do not hesitate to contact your attorney. Ask them, hey, what's going on with this? What do I need to prepare? We always want to make sure that you are getting the best representation possible. Now, if you are not a current client and you'd like to chat for free and you have charges in Southeast Louisiana, give us a call at 504-395-8867. We will talk to you for free and let you know how we can help. You deserve to feel informed and protected. Let us take it from here.